California's new gun laws just shattered the Second Amendment. Governor Gavin Newsom just signed a sweeping new gun control package that could change everything you thought you knew about your rights. From background checks on barrels to flat-out banning common handguns, this new set of laws targets law-abiding citizens in ways California has never dared before. This isn't about safety. It is a strategic blueprint to erode the Second Amendment one law at a time. In this video, we break down exactly what was signed, what it means for gun owners, and why it could spread to your state next. Welcome to Survival Lawline. No politics, no spin, just the raw truth about the legal battles shaping your future. Subscribe now and stay informed. Chapter 1. Newsom's New Laws. What just happened? In October 2025, California Governor Gavin Newsom signed into law one of the most aggressive anti-gun packages in recent history. Without fanfare or press spectacle, Newsom quietly approved 3 major bills that collectively gut key protections under the Second Amendment. Key points. AB 1127 bans a wide category of handguns, known publicly as the Glock Ban. AB 1078 limits gun purchases to 3 transactions per month. SB 74 requires background checks at FFLs for barrel purchases. These laws were signed simultaneously, bypassing public scrutiny. Newsom avoided his usual press theatrics, suggesting political calculation due to his potential presidential aspirations. But make no mistake, these laws are real, they are serious, and they are coming into effect whether or not the public fully understands what they do. Chapter 2, AB 1127, the so-called Glock Ban. AB 1127 targets handguns with features common in millions of legally owned firearms. It removes an entire class of semi-automatic handguns from California's roster, making it illegal to purchase or possess them once the law takes effect. Key provisions. Removes pistols that do not meet California's micro-stamping mandate. Explicitly bans several popular Glock models and other polymer-based pistols. Takes effect July 1st, 2026. Exempts law enforcement and other special categories. The law does not offer a grandfathering clause for future buyers. If your handgun falls under this new restriction and you plan to buy it after the deadline, you are out of luck. This law could set the stage for other states to adopt similar anti-roster bans. Chapter 3. SB 74. Background checks on barrels. Imagine needing to pass a background check just to replace or upgrade your barrel. That is now the legal future in California. SB 74 creates a new category of regulated parts by requiring an eligibility check on all firearm barrels, even if purchased separately. What the bill mandates: background check through an FFL for all barrel purchases. Applies even to simple part replacements or upgrades. Takes effect July 1st, 2027. Expands the definition of controlled components under California law. This bill drastically changes how firearm parts are treated. Barrels are not serial numbered receivers, yet under SB 74, they are regulated as if they were firearms themselves. Chapter 4. AB 1078 New Purchase Limits for Gun Owners. AB 1078 revives and expands a failed policy. California previously limited handgun purchases to 1 per month. That restriction was struck down by the 9th Circuit. Now, Newsom's version makes it worse. What AB 1078 does, limits all firearm purchases to 3 transactions per month. Applies to all types: handguns, rifles, and shotguns. Effective date: April 1st, 2026. No exemption for collectors or those with multiple licenses. By focusing on the number of transactions instead of the types of firearms, AB 1078 skirts around previous court rulings and creates new legal confusion. This law is built for litigation, and the lawsuits have already begun. Chapter 5. The Legal Response, FPC, CRPA, and more. The moment these bills were signed, gun rights organizations like Firearms Policy Coalition, California Rifle and Pistol Association, and Gun Owners of California sprang into action. Here's what the legal battlefield looks like. FPC issued a statement calling AB 1127 unconstitutional and promised federal lawsuits. CRPA and GOC are preparing parallel legal challenges targeting both SB 74 and AB 1078. Multiple organizations plan to file for injunctive relief before the effective dates. Legal arguments will rely on Bruin precedent and previous 9th Circuit reversals. The path to reversal will not be fast. Without emergency injunctions, these laws could be enforced for years while litigation drags through appellate courts. Chapter 6. The Legal Response from Gun Rights Groups. The ink was barely dry before lawsuits began. Gun rights organizations are already mobilizing to challenge Newsom's new laws in court. Some cases have already been filed, and more are coming fast. The Firearms Policy Coalition, FPC, immediately condemned the package and is preparing multiple lawsuits. The California Rifle and Pistol Association, CRPA, is actively building legal challenges to AB 1127 and SB 74. Plaintiffs are citing violations of the Second Amendment and SCOTUS precedent from Bruin. The courts will likely have to examine whether microstamping and parts bans are historically justified. These cases may end up in the same Ninth Circuit that struck down past California laws, and depending on timing they may climb back to the Supreme Court just like Duncan v. Bonta did. Chapter 7. Why these laws may not survive judicial review. Despite Newsom's victory in the legislature, the courts are where this battle will be decided, and based on recent Supreme Court rulings, especially Bruin and Caniglia, many of these new laws could fall. Bruin established that gun laws must be grounded in the nation's historical tradition. There is no historical precedent for mandatory background checks on parts or microstamping bans. The court also emphasized individual rights over collective interests like safety projections. Caniglia v. Strom and Duncan v. Bonta show courts rejecting overreach even at the circuit level. The legal momentum is not on the side of Newsom's agenda. His laws may pass through Sacramento, but surviving the courts will be an entirely different fight, one based on history and constitutional text, not emotion. Chapter 8. How this impacts California gun owners right now. Many gun owners think they have time, but California's new laws are like ticking clocks. They are already signed. They are already real. And while the enforcement dates vary, the window to protect yourself is closing fast. AB 178 begins April 1, 2026, impacting microstamping requirements for handguns. AB 127 prohibits any new microstamping ineligible pistols from being added to the roster after July 1, 2026. SB 74 mandates background checks for all gun parts and accessories starting July 1, 2027. Multiple new storage, insurance, and age-based requirements could be added in future legislative sessions. These laws do not just affect new purchases. They target how you buy, what you own, and even how you store it. Californians need to read these laws closely and prepare accordingly, not just to avoid penalties but to preserve their rights. Chapter 9. Could other states adopt these same laws? What starts in California often spreads. It has happened before with environmental rules, healthcare policy, and now firearms regulation. Newsom's new laws are already drawing interest from lawmakers in other blue states. New York lawmakers have revived a stalled micro-stamping bill, citing California as their model. Oregon and Washington legislatures are considering serialized part control and mandatory part background checks. Illinois lawmakers are studying California's gun roster system to restrict future pistol models. A multi-state coalition led by Newsom aims to standardize gun control laws across progressive states. This is no longer a local experiment. If California's laws survive court scrutiny, they could become templates across the country. That makes the coming legal challenges even more critical, because a win in California is a win for every gun owner. Chapter 10. Why every gun owner should pay attention. You may live outside California. You may think these laws are not your problem. But if history tells us anything, it is that legal precedents set in one place often dictate the rules everywhere else. Court rulings in California's Ninth Circuit can influence federal gun policy across the West. If these laws stand, they create a roadmap for Congress or other states to implement similar bans. Legal definitions established in these cases will affect future Supreme Court decisions. A win or loss here reshapes how judges interpret the Second Amendment for the next generation. This is not just about California. It is about national momentum. If these restrictions go unchallenged, they will spread. But if they are overturned, that sends a powerful message that the Constitution still has boundaries no legislature can cross. The battle has only just begun. Governor Newsom may have won a short-term political victory, but the real fight is just beginning. California's gun laws are now a test case for the future of the Second Amendment in America. If these laws are upheld, expect a wave of similar restrictions across the nation. If they are defeated, it will send a clear message that constitutional rights are not negotiable. At Survival Lawline, we will keep breaking down every bill, every ruling, and every courtroom battle that shapes your rights. If you believe in staying armed with knowledge, subscribe to the channel now and join the fight. Share this video, leave a comment with your thoughts, and let your voice be heard. Because freedom is never more than one bad law away from disappearing. Stay informed, stay prepared, and stay free.